Hey everyone, welcome back. Today's case involves a man identifying himself as an American state national who claims his public defender's request for a competency evaluation is simply a delay tactic rather than a standard legal step meant to protect his rights in court. For those unfamiliar, American state nationals are closely tied to the sovereign citizen movement, just under a different label. The arguments, however, are usually very similar. With that said, let's get into the case.
25 CR 2930, Mr. Chiarelli, appearances?
William Kellen on behalf of the people.
Josh Lindell on behalf of Mr. Chiarelli, who appears with us in custody.
Okay, this matter comes before the court for a status conference. The motion for the evaluation was filed. I didn't get a chance to stamp it, granted. So the court will, the court is gonna grant the motion for the competency evaluation and set it for, how much time do you need for the competency evaluation? Is it generally?
It generally depends on the evaluator. So once we have one appointed, they'll set a clearer timeline for us.
So is 60 days enough?
I think let's set out for 60 days for a first review. And if we get everything moving sooner than that, I will file something to add on.
All right. Let's do.
Yeah, absolutely.
June 1st.
I can accept that.
On behalf of the people?
We can accept that, Judge. Thank you.
June 1st at 8:30, okay?
Your Honor, I had a couple motions that I wanted to have.
You filed motions as well?
Yeah, I handed them to my attorney right here.
Yeah, if I can show these to Mr. Kellen and then approach.
Okay.
And then I also wanted to ask you a couple questions in relation to these. I started these a couple days ago when we had our conversations. I have a basic understanding of what I'm trying to communicate in them. I haven't had as much time as I'd like to finish my thoughts, as what I'm trying to communicate is, it's my understanding that polling my
Speedy?
Would be because of the fact that right to due process was pressed at preliminary hearing, and because I asked for a burglary trial and pressed right to burger it, that there is within statute, and I have not yet been able to find the exact statutes, all of those statutes relate to this. And there is a statute within Colorado state statute, as well as federal statute and constitutional law relating habeas corpus, as well as speedy trial and Fourth Amendment rights, that say the city of Denver and the state of Colorado, due to the fact that the public defender's office, the judicial branch, and the judge and magistrate's office, and the district attorney's office, if we get to this point and they have had the chance to hear a burglary hearing and my right to burger it as due process, and get to the point where they're trying to toll my speedy, they cannot.
In reality, they absolutely can. If an attorney believes a competency evaluation is necessary, the request is typically made to protect the defendant's Sixth Amendment right to effective legal representation, which includes being able to properly understand the proceedings and actively assist in their own defense. While that process can temporarily delay the case and impact the right to a speedy trial, it is still considered a standard and appropriate legal safeguard within the court system.
Okay, I'm gonna stop you right there. I haven't had a chance to review this this paperwork, but I just want to make sure that I explain. And I know that Mr. Lindell, I'm familiar obviously with Mr. Lindell, and I know that he's explained some of this to you, but the Burgerud hearing is something completely different than what's going on with tolling your speedy trial. The reason why your speedy trial was told, you were scheduled for trial, I believe, next week. But the reason that it was told is because there's been a request for an evaluation. That evaluation can't be done before your trial date, and it can't be done before your speedy trial runs out, and that's the reason why it was told. It's required to be told when essentially you're requesting that something be done, but it can't be done within the time period that we need for that we need for it to be done, and I need to get the information so that I can review it and make sure that everything is okay with you being able to move forward to trial.
Right.
But that's completely a different situation than the Burgerud. I think last time you were in court, you mentioned that you were did you mention, I can't remember, whether or not you were interested in getting a new attorney? Is that what you said?
That was the reason that I had raised Burger after preliminary. And my point...
The preliminary hearing would not have been done in front of me, so I don't know when it was done. It must have been done a really, really long time ago.
It was almost
a year ago.
It was almost a year ago, correct?
Yeah. So I don't know anything about what happened there. I don't have those particular notes in front of me, but the Burgerud hearing is really for the purpose of determining whether or not there's some kind of a conflict between you and your attorney. As of right now, I'm not seeing that there's a conflict between the two of you, so I'm not going to order that Burgerud hearing. I want to first get the information from the evaluation that you're doing before we can move down any other road. Let's get that information that's, in one place so that I can review it. In the meantime, I'll also review your motions, okay? And then I'll look at those statutes that you have listed in here, all right? Okay, so what I'm gonna do is I am going to set you in 1H. That's the courtroom downstairs, because it is because of the kind of evaluation that you're doing, okay? And I'm gonna set that for, it's gonna be next Tuesday. Okay, I'm gonna set it for next Tuesday, and then from there, they'll do any additional evaluations that they need, okay?
Okay, thank you.
All right, so that'll be Tuesday in 1H at 1:30 p.m. All right?
Thank you.
All right. Do you have any other questions, Mr. Chiarelli?
Not at the moment.
If only that were the case, but he's far from finished. He still has plenty of questions left, and the judge does a remarkably thorough job of addressing each one and explaining the situation step by step.
I know, like I said, those motions are good how they are, and I know that I had not finished the thoughts just because I had not had time. So I know that I was going to attach at least one or two follow-up motions to those, because those are complete, but they're not finished.
Okay, I'm going to give these back to your attorney. I will tell you that generally my position is that when someone has an attorney, I don't accept motions from pro se parties. And part of the reason is because pro se parties don't necessarily understand, criminal law is very, it's very complex, and they don't necessarily understand everything that's going on. But when you speak to Mr. Lindell, you guys can look at it together, and then once you look at it, he'll be able to make a decision as to whether or not he wants to expand on some of the motions that you file, and then he can file it under his name, and then I'll review it, okay?
I'm trying to I'm having, I guess, a hard time understanding. Maybe I'm doing an ineffective job of communicating this.
No, you're not. Go ahead.
And that's why I wanted you to look at these first before I went on. Maybe if I left these with you, it would be helpful, because I guess the time that I'm having a difficult job understanding is because we've already had competency evaluations. We've already had a competency hearing where I was found competent, not only to proceed, but to assist. Beyond this, the case law, the statute, and everything that I cite on these motions, and my understanding of my civil rights as an American national citizen and as a Colorado state citizen, say that due process within the city and state of Denver and within the federal government and the national government of America, say that if for some reason within 182 days of preliminary hearing in Colorado, the city and state that has brought criminal charges against me that does not have an indictment entered or has tried to bring indictment against me or has brought indictment against me, there is not a trial brought forth. It is upon that city and state to then file dismissal.
Okay, that's a little inaccurate.
Right.
I understand where you're going. You're basically saying that you have a right within 6 months to go to trial after you enter your plea of not guilty.
No, what I'm saying is that the error would be the same upon the judge or the magistrate, because if for some reason my attorney now, who is saying there's a competency issue and he is not ready to proceed to trial, it would be the same as the district attorney's office saying that they are not ready to prosecute because I raised Burger it and said we have some sort of conflict that needs to be heard in front of a judge right after a preliminary hearing. So the judge had their chance on behalf of the city and state of Colorado to say, yes, defendant, we hear you. And we know as the city and state that the district attorney, the public defenders, and the judge need to solve our issue before we reach speedy trial. We have an issue that you as a defendant, an American state, and a Colorado state citizen is bringing before us.
What's the issue that you need to address?
My issue was that I believed my attorney was not going to be ready before speedy trial. And I believed he was going to try and violate my due process. And now I believe he is using a stall method as competency again that has already been raised, already been found competent by the courts, and already gone through competency evaluations. So I believe now he's trying to get my due process or speedy trial told or speedy trial pushed out. So I believe now, instead of being ready for trial like he should have been within 182 days of that preliminary hearing, and instead of the courts hearing my right to burger it and having a burglary hearing in front of them, I am now being stalled and my rights are being violated.
As already explained, this is not considered a violation of your rights. The purpose is actually to protect your 6th and 14th Amendment protections throughout the legal process. And if this were truly just a tactic to delay the case, your attorney likely wouldn't be requesting a temporary tolling of your speedy trial rights. He would be pushing for a complete reset of the timeline instead.
This is my point of these motions, and this is the point of I know that the law exists. I can find the exact statutes. I've already found multiple statutes in Colorado law that support this and prove it beyond reasonable doubt. And I know this for a fact. This has been my point since preliminary hearing, when I felt I was misrepresented. I felt that this case could have gone away at preliminary hearing. I felt we had an officer lie on stand.
All right, I'll say, Mr. Chiarelli, we went to motions on this case, and there were a few motions filed by your attorney. So I had a chance to look at the videos in your case and hear the testimony in this case. And based on what I saw, I determined that there was enough to move forward in this case and that the case should not be dismissed. That was based on all of the body-worn camera videos that I saw. And I think that, you remember we were here for a few hours. So this case would not be dismissed based on the evidence that has been presented in the case. And so I've already found that, and I'm sure that had been found well in advance of the case being in front of me, or else Judge Johnson or the county court would have, dismissed it, but they didn't, and neither did I. So that's one piece of it. The second piece is, I think that some of what you're saying, I understand what you're saying. It makes sense what you're saying as to the timeline of where you are, and whether or not you believe that Mr. Lindell was ready to go to trial. It seems to me what you're saying is that you believe that he wasn't ready, which is part of the reason why he's requesting this competency evaluation, and that the competency evaluation isn't a valid evaluation because it's already been done, but in effect that it's a stall tactic. That's what you're saying. So I had a chance to look at the sealed motion for competency that was filed in this case, but I also had a chance to look at the previous evaluation that was done. Based on what I've seen from what Mr. Lindell has filed, I can certainly understand why he would believe that another evaluation would need to be done. That's based on his communications with you directly. It seems to me that what you're saying, you're a little kind of like scattered, but I understand what it is that you're saying. You're making some sense to me. But once these evaluations have been filed, I have to make sure that someone who is certainly more educated than I am on these kinds of issues takes a look at you, talks to you, listens to these kinds of things that you're saying, and then makes a decision as to whether or not you can move forward. So I know that it seems like, it's getting kicked back a little bit. I can assure you that as soon as they come back, if they find you to be competent, I will give you the earliest possible trial date that I can. Everything in this, the only thing that's ready to go, it's pretty much ready to go. The issue is when at this point, but I need to make sure that you're okay so that later on, any future, the Supreme Court and the Court of Appeals don't look at me and say, why did you allow it to move forward when there was this issue of competency being raised? I don't want it to be reversed later on. You understand?
Absolutely.
And so to a certain extent, what I'm making sure is I'm making sure that your rights are protected, and I'm making sure that this doesn't get dragged out even longer later on. All right? Does that make sense?
It does. And those parts make sense. I'm still not understanding what I necessarily asked.
About the Burgerud or about
how it protects my overall rights that were exerted insofar as due process, and how allowing Speedy to be told in this moment and this instant.
Well, there's no way that the evaluation can be done before June 2nd. That's the problem.
Absolutely, and I do understand. I'm just not understanding how that falls upon me instead of falling upon the city and state as fault.
The city and the state are not the ones making this request. Your own attorney is requesting the evaluation, and he's doing so as part of his responsibility to represent and protect your interests in court.
I'm not asking for this.
Right.
The person that's asking for this is you. And your defense attorney. But your defense attorney is asking this based on what's
needed by me that I'm not understanding. Correct.
Yeah, and it's based kind of on the interactions that you guys are having and his discussions with you. So because I'm not having direct discussions with you outside of court, I have to defer to him about what he sees and what he believes is necessary, because you have to be able to help him when you go to trial so that you can get the best possible outcome possible, right? And if he doesn't think that you can help him right now, then he's asking for someone to make sure that you're capable of assisting him in his trial, all right? In your trial, actually, not his trial, but your trial, all right? And the reason why we told it as opposed to waiving it
I get that.
is so that we can just pause it.
That makes sense. I just wasn't sure how I was personally benefiting versus I wasn't personally seeing the benefit from.
The way that you benefit is by everyone making sure that you're ready, that you're competent, and that you understand what's going on during the trial, right? And that you can help him. You need to be able to assist him with your defense so that, you know, if you testify, you're testifying logically for the jury. If you don't testify, that I'm confident that you understand what your right is and what right you're waiving.
So
I need to be confident in those things.
So this new hearing that's on Tuesday, is it a more extensive evaluation? What's different than the last evaluation, and why is it?
So the 1H courtroom, it's not going to be an evaluation done initially, but the 1H courtroom, that courtroom is designed specifically to address and they know the processes, certainly more than I, about what the mental health process is, what the competency process is. They have more resources down there than we up here to deal with those kinds of questions.
Okay, so what would make you believe that myself as a defendant and the court that prior determined a perfectly competent to proceed and assist determination would benefit more from having my due process extended and speedy trial told, rather than, let's say, due process earlier heard in a burglary hearing as I represented by myself to the courts? I guess that's what my overall question to the court here.
Go ahead.
And this is mainly for a record at this point for the motions and stuff that I'm having, because this is the issue that I'm having.
Go ahead.
My overall issue and my point to you is not to be a pain in the ass, is that my feeling to the courts is that my rights in this example are being violated only in the fact that the city being represented by the magistrate office, by the judge's office, the district attorneys, and the public defender, as they are all paid by the same offices, they're all paid by the city and state, are all telling me that I, as the defendant, am being better represented by going to another competency hearing that I didn't want, I don't want, and I don't feel benefits me, instead of going to a burglary hearing where I could have been heard on an issue that I actually wanted and I actually felt would benefit me as the defendant.
Okay.
And that's my issue.
Okay. So instead of going to the competency hearing, you're saying that you would prefer to have
I'm saying I would have already preferred it. And I'm saying that in doing this, in this moment, the city and state is in violation of my due process.
This is not considered a violation of your rights. In fact, the bigger issue would be if an attorney believed a competency evaluation was necessary and chose not to request one. There is, of course, another option. You can represent yourself, but in most situations, that tends to create far more problems than accepting a brief delay to confirm you are fit to proceed with trial. Ultimately, it is usually in your best interest to allow your attorney to manage the legal strategy and handle the case using the training and experience they were appointed to provide.
I know that at least the caption of your motion is to dismiss based, it would seem to me, on the arguments that you're making.
Well, I wasn't sure what to actually write on the motion. I know that's the overall, like I said, that was one of the hardest parts on the motion. I'm not a lawyer, but that's where the end of it ends, in theory, is that because
of all of these violations that you want your case dismissed.
At someday, how can the city and state of Colorado and the city of Denver try me on these charges when they're violating my due process? That's the end goal.
Right.
But is that actually possible and obtainable without massive legal breach? Probably not. That's probably out of the realm of cognition and possibility right this second.
Okay, well, let me tell you what I'm going to do today, and I'm going to tell you what I'm not going to do today, okay?
Absolutely.
What I'm going to do today is I'm going to set your hearing for 1H. Now, they can come back, perhaps they can come back a lot earlier, and if they do, then we'll be prepared to go to trial. All right. But what I'm not going to do today is dismiss your case.
Of course.
Okay. But what I'll instruct your attorney to do is he can certainly upload those documents that you filed. I'll take a look at them. While you're set downstairs, I'll take a look at it once it gets through the system, and I'll see exactly what's going on and look through your file a little bit in more detail to understand where the timing is of all of this. But it doesn't look, based on my file, that any kind of burglary hearing was held. I don't think it would be appropriate at this time to hold a burglary hearing based on the allegations that are being made. But if when you come back, if they've determined that you are competent and you want that hearing at that point, I can certainly do it then. But keep in consideration, though, that if you do a burglary hearing, that then and if I were to grant your request to get a new attorney,
Then we're moving due process along.
well, no, then what happens is then I have to get a new attorney on the case if it's granted. And then I would have to set it over again for your trial so that the new attorney can get caught up to speed about what happened, review the transcript of my oral ruling at the motions hearing, and then be prepared for trial, right? So that could potentially also kick it down the line a little bit, but I want you to be aware of that when you're, when you're thinking about it and you're preparing your motion, that any future hearings beyond what's going on, unless it can take place together, it's going to further kick the can down the road. And I know that that's not what you want to do.
No, not at all.
But what's important to me is that you can help your attorney, whoever that attorney is, and that you're satisfied with the representation of your attorney. So I would encourage you to sit down, talk to Mr. Lindell a little bit more about what's going on, about your case. I know that he's familiar with your case because, I heard the arguments that were made. But talk to him and see whether or not there's going to be the need for it, so that maybe we can move this case forward earlier to trial after you come back before me rather than later. All right?
Yes, Your Honor. Thank you so much. I appreciate you.
Thank you so much, Mr. Chiarelli. Do you have any other questions?
No, Your Honor. I think that satisfies them. Absolutely. Thank you. I appreciate your attention and your
Of course.
answers. I appreciate it very much.
All right. Okay. So you'll be down in 1H next week. All right. And then you can certainly ask Judge Arnold anything that you need to ask her as well.
Yes, thank you.
And Judge, just to clarify, the court did not accept the written motion to stay, right? There's an instruction to file those, is that right? So
I can't accept anything up here. He needs to, Mr. Lindell can file them and then I'll take a look at it.
Understood.
And if I need a response, I'll request one too.
Thank you.
Thank you, Mr. Chiarelli. Have a good day.
Thank you, Your Honor. You have a great day.
All right, that wraps up today's video. Overall, it seems the defendant may be misunderstanding how this legal process actually works, because if the goal were simply to delay the case, there are much easier ways to do it than requesting a competency evaluation. In my opinion, the smartest move would be to complete the evaluation first and, if found competent, address any concerns about legal representation afterward. Let me know your thoughts in the comments below, and if you enjoyed the video, don't forget to like, subscribe, and turn on notifications for more content.